All right, hi, welcome back. Attorney Steve Vondran here. We are talking BitTorrent litigation, tales from the trenches, and Strike 3 Holdings. So this case is, here's a ruling that came out. You can see it up here at the top, filed 7/23, July 23rd, 2021. And there's your case number. It's a Strike 3 Holdings case, as you can see here. And it was a typical case where Strike 3, they filed their John Doe lawsuit. They have the confidential, anonymous John Doe, and they go and they try to get the name and the address of the internet subscriber. And, well, I'll just read it here to you. This case arises from the alleged illegal download and distribution of adult films to which plaintiff Strike 3 Holdings, LLC, owns the copyright. So these are copyright file sharing and distributing of copyrighted files. That's the issue. Defendant is currently unknown. That's why he's John Doe, except as a subscriber IP address, the IP address used to download Strike 3's copyrighted materials. To identify the subscriber, Strike 3 has filed a motion to leave to serve a third-party subpoena prior to the Rule 26 conference. Usually you have to wait until that, but the courts are routinely allowing them to serve that subpoena. Strike 3 specifically seeks discovery from Verizon Fios, the internet service provider that provides internet service to the IP address here. See the memorandum, so forth and so on. With this subpoena, Strike 3 seeks the name and the address of the subscriber of the IP address, thereby identifying the defendant, John Doe. After considering the motion, the pleadings, and relevant law, the court granted, like I said, as routinely they're doing, Strike 3's leave to serve its third-party subpoena. Okay, so let's take it further here. That's not really the main focus of why I want you to check out this argument here. But I want you to see, if I can get this to move over here. Hang on one second there. Okay. But denies without prejudice Strike 3's request for a protective order. So this is something new. Now, protective order in law is basically where you want to protect someone from annoyance, harassment, embarrassment. So you seek a protective order, and the party that's seeking the protective order usually has to show good cause for that. And normally these have been granted because Strike 3, the plaintiff, has tried to preserve the anonymity of people. Why? Because they could be wrong. Maybe the subscriber is not the downloader. Maybe it's a brother. Maybe it's a kid in the house. Maybe it's a neighbor. Maybe it's a frat house. Maybe it's a coffee house. Who knows? So the courts have routinely granted these motions for protective orders. So that's really what this video is about. I want to just point it out right here. Federal Rule of Civil Procedure 26C, C as in cucumber, permits the court, upon a showing of good cause, to issue an order to protect a party or a person from annoyance, embarrassment, oppression, or undue burden or expense. So usually Strike 3 will file these just to kind of keep things quiet, so the names aren't coming out, so they're not accused of, shame settlements and whatnot. Here we go. Good cause exists under Rule 26 when justice requires the protection of a party or person from any annoyance, embarrassment, oppression, or undue burden or expense. Protective orders may also be used to limit the manner in which confidential information is to be revealed. The party requesting the protective order generally bears the burden of showing good cause by demonstrating specific evidence of the harm that would result. Nonetheless, trial courts have broad discretion to issue and set the terms of a protective order, and may do so on their own accord, sua sponte. And they can deny them, as we're going to find out in this case. And I haven't seen a lot of cases where this has been denied. If you want to pause this and read more about the case, you can. But I'm just going to go to this section. To me, this is the interesting breakthrough, I would say, and maybe not necessarily good for defendants in these cases. But again, this is from D.C. Court. Although Strike 3 has not demonstrated that a protective order is warranted, temporary restrictions on disclosure are appropriate to protect the subscriber's right to seek confidentiality. So in a nutshell, what this court's going to do is deny the motion for a protective order, even though, like I said, we've seen them granted just routinely. And now, you can read what's highlighted here if you like. And now the court said, look, I'm going to give you 30 days. If the defendant gets identified and the defendant is notified of the action, the defendant will have 30 days to bring the motion for a protective order. So this is something new. Again, I haven't seen it right here. It says here, to avoid prejudicing defendant's ability to seek such an order in the future, the court will restrict the disclosure of defendant's name and address for a limited period of time. So you go down here, the court says, look, if the defendant wishes to proceed anonymously in this litigation, defendant shall make that request through a motion for protective order. Any motion shall be filed within 30 days of when defendant receives written notice of the subpoena from the ISP. So the ISP should notify you. You have 30 days to then seek a motion for protective order. So this, gets the clock running, and as a defendant, puts additional burdens on you to get something filed. If you're not getting your case settled, it's probably gonna help them get cases settled quicker, I would assume, because now you're going to have to pay money and set a motion and file a motion for a protective order. So you can file the motion under seal, as it says here. I have a video about filing documents under seal. I will put that in the description box below. It's a very precise process that needs to be followed. And here it is, and the only restriction is to preserve defendant's ability to seek a protective order. Strike 3 shall refrain from identifying defendant's name on the public docket for a period of 30 days after receiving the subscriber's identifying information from the ISP. On or before September 7, 2021, Strike 3 shall file a status report with the court briefly outlining its progress, including providing an expected completion date of the discovery allowed by the accompanying order and addressing whether Strike 3 has received any formal or informal request for anonymity from defendant. So, in other words, you need to keep your eye on the ball, and depends what court you're in, but you may need to jump on it and file for a protective order, quick on early in the game to give yourself some time to review the case, review the allegations, work out a potential early settlement, and those kinds of things. So that was an interesting case out of the D.C. court. This was just a couple months ago, and the court denying plaintiff's protective order, which doesn't happen too often. So that's a new issue we've seen here in BitTorrent Strike 3 law. Don't forget, Vondran Legal, recently identified by Unicourt.com as the top copyright infringement defense law firm in the United States. No applause, please. In terms of cases, number of cases handled. So we handle just about everything, quite a few cases, I should say, in California, Eastern District, Northern District, Southern District, Central District. Okay, so if you need some help, you know where to find us on the web, attorneysteve.com. That's attorneysteve.com, the first name in legal services. This is general legal information only and not legal advice.